It's December 28th, 2025. It's 3 minutes till 8 Central Time. It's time to watch some court. This is the Court Gallery. It's the last Monday of 2025, ladies and gentlemen. And rightfully, we should be watching Thurston County PPO, but I swear, everywhere I look across CourtTube, everybody's watching those court cases, and I refuse to watch the same case everybody else is watching on the same day they're watching it. So we're watching something else because I actually think I found something a little bit more interesting. We're starting things off in Judge O'Donnell's court in Ohio, ladies and gentlemen, where he's got some very poignant things to say to a young lady who has an interest in being a nurse in the future, but is a dancer today. And then we're moving from Ohio all the way back to Michigan, but we're not gonna go see Judge Simpson. No, we're gonna go see Judge Middleton. And we're gonna see a lot of people really pushing Judge Middleton on the last Monday of the year. It's a landlord-tenant docket, and it's a small claims docket, ladies and gentlemen. It's all interesting. And it's gonna be Blackboard Live all night long, because that's how we do it. And we're live. And it all starts right now.
After the filing of the indictment, the defense did file a motion for intervention in lieu of conviction, which the defendant was referred for the appropriate evaluations. It's my understanding that report has been completed, and the state is prepared to proceed today.
All right, Mr. Hinton.
That's correct, Your Honor. We're in a position to proceed as well.
All right, you got a motion. I'll address the motion.
Yes, Your Honor. We did file a motion for intervention in lieu of conviction based on my reading of the various reports that were prepared. My client is eligible for said programming. I think that because this is a drug possession case, it certainly aligns with the intervention. I know that Ms. Riley is trying to become a nurse. She's already taken some steps in that regard. I think this would be an opportunity for the court and the probation department to intervene, address the drug issue, which showed up in the form of this conviction. And then there was also marijuana use, even though it's legal, still seemed to be a way to cope with anxiety and those sorts of things. I know that the assessment from Lake Geauga recommended an intense outpatient program, also recommended a mental health assessment and drug and alcohol assessment, as well as AA or 12-step meetings. I do believe that that would be an appropriate intervention plan. Riley does reside in Toledo, so certainly would make sense that she partake in her intervention plan in Toledo in the event that the court was inclined to grant same. Thank you.
All right. Ms. Riley, do you want to tell me why I should grant your motion for intervention?
Your Honor, since the beginning of my case, even on paper since the first day, I've been nothing but honest. I had
No, you haven't. You haven't been the least bit honest. But go ahead.
I made my way to come back and forth to Cleveland from Toledo to see my PO and make my way here. I am 19. I don't have a car. I'm not looking for any excuses or any grace with that, but I have been trying.
All right. What were you doing in Willoughby Hills?
I was on my way to PA,
For what?
Pennsylvania, to dance
To dance where?
at a club.
Kind of club?
A strip club.
Okay. Now, why when I read this pre-sentence report, don't I know that?
I mean, I don't know.
What were you doing with Martez Brown?
I was driving. He doesn't, I don't, if he does,
How do you know Martez Brown?
I met him in Toledo,
Okay, where did you meet him in Toledo?
at a party.
Okay, kind of party?
It was, a block party. It was
A
around
what?
the 4th, it was a block party around the 4th of July, everybody.
In when, 2024?
Around then, yes, sir.
Okay. And then what was your contact with Brown since then?
We were good friends. He helped me get around to where I wanted to go to dance at.
Okay. Who was the other girl in the car?
The other girl was one of my friends, Beyonce.
Okay, what was she doing? Was she going to dance too?
Yes,
Okay, so you only met, you indicated here that the only reason you know Brown was social media contact.
that's the only way that we contact each other. That's not the only
Okay.
way that I know him.
Why is that? Does he arrange this dancing?
No, he just took me to the places I wanted to go
Why?
to dance.
What was in it for him?
There was really nothing. Me and him, we messed around a couple times, things of that nature. Other than that, it was very broad, and I didn't have contact with him on an everyday basis.
Why did you tell the police you were there to see family members in Willoughby Hills?
He said that, and I don't know what they went along with, but we were going to the gas station when we got pulled
Well, you
over.
weren't going to the gas station because you passed by like 3 or 4 gas stations.
That's also what the police said, but I was just in my GPS and going wherever he told me to go.
So at 2 in the morning, you leave the Fairbridge, which is it's not really a hotel. It's a place where drug transactions and prostitution takes place. That's what it is. It's a drug den and a house of ill repute where nothing goes on but drugs and prostitution. So the 3 of you leave the Fairbridge. Did you check out of the Fairbridge at 2 in the morning?
No, he was supposed to check out the next morning because the rental.
Okay, so why in the world were you getting gas? Why did you leave the Fair? How long had you been at the Fairbridge?
I think we checked in around 10, maybe.
Okay.
My mother was in Cleveland at the time. I was supposed to see her in the morning. He was supposed to turn in the rental because I guess he got the
So
rental.
why did you, if you were leaving in the morning, to check out in the morning, why were you going out to get gas at 2 in the morning?
He told me, get in the car and could drive to that address, the gas station, wherever the gas station. I'm not from Cleveland. I don't know where I was going. I was going where he told me to go.
It's not the point of where you were going. The point is, you guys, the 3 of you get to the Fairbridge at 10 o'clock. On your way back from Pennsylvania?
No, I was supposed to be going to Pennsylvania in the morning after I seen
Okay,
my.
then why were you headed back to Toledo?
I
Because
was
you had to get
going
a different rental car the next day.
Yeah, he had to get a different rental car. He got the rental from Cleveland apparently because that's where he got it.
All right, see,
I got picked up in Toledo and I drove from Toledo to Cleveland
when?
that night, that same night, well, a couple hours before that. I'm the only one with license, apparently.
When was the dancing scheduled to take place?
There's no schedule. I was going to PA. I was going to get a room for about a week or two, and I was going to stay down there and dance, and he was going to
You know
find
what
his
this
way.
sounds like to me? This sounds like prostitution.
I'm a
And
travel
Brown-
dancer.
And Brown sounds like he arranges the prostitution of you, Beyonce, and whoever else he does this with.
Your Honor, if I may, I'm not a prostitute.
Okay? I said it sounds like it. Okay? I can't-
That's what you're.
I can't prove anything, but Brown, who you met 3 times through social media, what you say in the pre-sentence report, now you say you met up at a block party 10 months before this, has 2 young girls in the car, leaves from Toledo that night, on the way to Pennsylvania, checks into the Fair Bridge at 10 o'clock at night, and is directed you to get gas at 2 in the morning, but you're gonna go right back to Toledo where you just came from, because he's got to get another rental car.
No, he had to get the rental from Cleveland. We weren't going back to Toledo.
Okay. It's amazing how the story changes as we go along. How old is Martez Brown?
I have no idea.
How old is Martez Brown, Ms. Olesh?
He was born in 1988, 36 years old.
Sounds like he's in jail, Your Honor. We haven't had any recent contact with him.
I don't know where he is. I don't know why he's in jail.
In Toledo.
He had
Lucas
several
County.
pending charges in Lucas County.
What kind of charges?
Theft, if I'm remembering correctly.
Were you involved, when you got involved in that theft in Toledo, was that with Martez Brown?
No, that was from when I was 17 years old, a kid, and I was with my friends.
I don't know how that firearm got in a rental car. How'd that firearm get in a rental car?
I got picked up right in Toledo, and I drove from Toledo to Cleveland. I didn't even know there was a firearm in the car.
When did you arrange this dancing to take place in
It
Pennsylvania?
was the night before.
How did you do that?
I literally said, I made a post on Facebook saying that I wanted to go dance in PA, and he slid up on it and said, I'll take you.
Why in PA?
Because I heard that PA is a lot of attraction there, and the clubs there,
Where in PA?
Pennsylvania.
I know, where?
I don't
Big
know.
state.
Erie?
Huh?
It was Erie, I don't know, Erie, Pennsylvania, I don't know. I can't remember, it was so long, I never got to go. The plans never fell through.
What was this mushroom doing in your purse?
I've had it in there for a couple months since around my birthday, and I forgot it was in my purse.
What were you doing with it? Why was it in your purse?
I used to take mushrooms, but I wasn't under the influence of the mushroom. It was sitting in my purse.
It's a long time for a mushroom to sit in your purse. You didn't know it was there?
I forgot about it.
What else is in your purse?
I don't take them on a regular.
What else is in your purse?
What was in there that night?
Yeah.
It was just a mushroom that was in there. And the police told me that the key to the safe was in my purse, but I didn't know about that because my purse was sitting in the passenger side with Martez right by his feet. I don't know if he slipped the key in there or whatever the case may have been, but I didn't know that until the police told me.
Well, what else is in your purse normally?
My phone, lip gloss, money, like, I don't know.
And you didn't notice for 3 months that a mushroom was in your purse?
I wasn't.
See, I don't believe that either.
I mean, I know it was in there. I just wasn't, or I wasn't thinking about it at the
Okay,
time.
I don't know what's going on with you. I suspect what's going on with you. Okay, so you want me to place you on intervention and develop some sort of plan so that you stop going in and out of courts, right? What is your problem that needs to be addressed on intervention?
I struggle, with anxiety, my mental process. That's why I do smoke marijuana and things of that nature. Mushrooms just to escape. I have a lot going on. I've been an STNA since 16. I broke my leg, my back pain, whatever the case may be. But just trying to go through life and figure things out. That's how I cope.
What are you trying to figure out with Martez Brown?
I'm not trying to figure out anything with
Okay.
him. I haven't had contact with him. That's what I keep saying.
I know what you say, okay, but I have a hard time believing what
Well,
you
it's
say
true, he's in
because you're not honest with me since I've been in here.
Yes, I have been honest with you, Your Honor. I haven't really had contact with him since I've been in jail back in June.
They don't have any clubs to dance in Toledo?
Yes, I danced in Toledo also as well. I travel dance. I don't want to stay in Toledo.
Okay.
But I wasn't coming through your city to be a menace or cause disruption or anything like that.
That's not the point. Okay. You weren't much of a disruption. You probably would have been more of a disruption at Willoughby Hills. Got a little bit more into what was going on with the three of you guys, but the problem is that you don't want a conviction for this possession of mushrooms, right?
Yeah.
Because that would affect your STNA.
It would, Your
In
Honor.
nursing school at that.
Right. Okay. But your primary focus seems to be the traveling dancing stuff.
It's not my primary focus. I have to pay for school.
I think if she could get the STNA, it would assist with that as well.
Well, she is an STNA.
I mean, if she can continue on that course.
In your position to stop those contests.
I think
So
that-
how long have you been traveling dancing?
Just since I turned 18. But I've been an A since 16.
And so what is the extent of your drug problem?
Before I started, before my PO let me know that, it was 4 or 5 times a day, I smoked marijuana.
How can you work as an STNA if you're getting high all the time?
I mean, not at work or before work, but after, if I go, not the days that I'm working, but when I go home after work, I'm, as soon as I get off of work, I'm smoking. Before I wake up, a couple hours before, just to.
Well, so why do you smoke it?
My anxiety,
What do
anxious.
you, what's
I
your,
feel,
what does your anxiety stem from?
ooh, I'm not quite sure. I think that's why I need to figure it out. I have a lot of trauma and things of that nature. I've been through things in life. So it's just getting through the day and coping. It's hard.
Well, I don't know what your trauma is, because it's not contained in any report, because you never brought that up to anybody.
I mean, my PO, and when I talked to them, we talked a little bit, but
I know that mental health evaluation was recommended.
I know that, but so what? Based on what?
Well, it makes me think she may have brought some of this up, even though it
But
wasn't
isn't it
detailed.
important for me to know that stuff before I implement a plan? How can I implement a plan if I don't know what I'm trying to resolve? That's the problem. Nobody can be honest about anything. So, this is like a big cattle call. You know, we just bring them in, we bring them out, we bring them back in, we bring in another group. Get them through, they come back. Everybody comes back
I won't be.
because there's no effort to solve the problem. Now, how am I supposed to help you solve your problem if I don't know what your problem is? How is it humanly possible to solve an unknown problem? But your concern is not solving your problem. Your concern is getting the hell out of Lake County and getting back to Lucas County so you can do whatever it is you want to do. That's your concern.
Mhm.
Yes.
That's why I came to turn myself in so I could handle my matters.
Well,
I never ran.
The guy who, the
Second.
bondsman that posted your bond, who is that bondsman?
I'm not for sure.
How did you, when you called to get out on bond, what bondsman did you call?
I didn't call anybody.
Then how did he show up with the bond money?
In the
Let me
beginning,
guess.
when I bonded out in June, I didn't bond myself out. It was somebody else. It was
Who
somebody
arranged
else.
it?
I do believe Martez
Right.
and his people. I'm not even, I don't even know who's all on the bond list. That's my thing. I was just paying it after I got out. I've been paying when he went to, I've been paying it. Because my bail bondsman called me. To my knowledge, I didn't even know who bonded me out of jail, to be honest.
Wow.
Then, when I missed my court date on the 25th of November, I was in contact with my PO and Corey, and I made plans to turn myself in. I don't even know who I was really speaking with at ABC Bail's Bondsman. He told me to be there at 4:00, and that's what I made sure I was there at 4:00 to turn myself in. I don't know how this goes. I've never been in trouble before.
Well, you have been in trouble before.
I've never been to jail before.
Now, in the Lake Geauga Recovery Center's report for this intervention, the evaluator talks about cannabis use disorder, which is moderate in nature. And what's your history of using these mushrooms?
I used them about twice. It's not a reoccurring habit with the mushrooms. I did them for my birthday and a little bit before then, and after that, it was pretty much over. I don't use
Okay.
mushrooms on a.
You told the evaluator the only time you ever used it was on your birthday in 25.
Yeah,
Just told me twice.
so once or twice. But maybe a day before my birthday, and a little bit before my birthday, and on my birthday, but it was pretty much that one.
She says in here that you deny any history of mental health treatment as well as any history of abuse and or trauma. That's not what you just told me a little bit ago. So which is it?
I've had some trauma, but I
What?
don't like to speak on it.
What?
I mean, I have some things that happened in life that I don't like to speak on. But,
Right. So, do you understand why I'm asking you that?
yeah,
Why? Why am I asking?
because there is not, what I told the reporter and what I'm telling you is kind of wishy-washy, but I mean,
Well, it's
I
not
was taught.
wishy-washy. It's not wishy-washy. One's true and one is untrue.
It's true regardless. I didn't, well, I would tell a therapist that I got raped or whatever the case may be. I wouldn't tell a random reporter that I don't know, like, oh, okay, like, you get what I'm saying?
But you know what I'm saying, okay? What I'm saying is, you want me to place you on a plan that's going to hopefully get completed to prevent you from coming back to court either here, or Lucas County, or Pennsylvania, or anywhere in between. But I don't know what the problem is. Therefore, I can't implement a plan if I don't know what the problem is. And if I can't implement a plan to solve the problem will recur over and over again. And you won't be 19 coming in here, you'll be 39 coming in here. Hanging around guys like Martez Brown and Beyonce and whoever. Don't shake your head. No, I'll never be back again. I'll never be back again.
And this is not the life I want.
Okay.
I've sat with my consequences twice now, and I know that that's not what I want. Like, I don't know what you want me to, like, depression, anxiety, I've been, like, raped. Like, what else do you want me to say? Like, that's
don't
it.
want-
That's how
I don't
come
want you
every
to
day.
say anything. What I want you to do,
Been
what I wanted you to do was be truthful with the people evaluating you so that I would know what the problem is. So the problem could be addressed. So right now, okay, you and Mr. Hinton want to get on a plan and go to Toledo to implement the plan. Well, here's a shock on me to follow up, to make sure that you're implementing whatever plan I come up with, which is ill-advised, okay? This is a disaster in the making, is what it is. Problem. Department who arrested you guys. You've made this process very difficult from the start. Very, very difficult. For what you want, okay, you have made this process for me impossible. I'm trying to figure out statutorily why this isn't even an intervention case, if all it is moderate cannabis use disorder. Apparently you can stop whenever you want to because you go to work for 8 hours at a time and don't smoke. And then the other 16 hours you're smoking. So you can stop, but you don't want to stop. Maybe, I don't know. It seems like from what you're representing to me as you stand here, that the root of your problem is some sort of past trauma and or abuse that I don't know anything about. And if you could manage to deal with that problem, then the other problems would go away, the depression, the anxiety, whatever it is. Of course, that isn't in here anywhere. Okay. There are no mental health concerns in this report that was presented to me.
Those were literally my words I told her. She said, how do you feel when you do not smoke? I said, I'm irritable. I get very angry. I get depression episodes. I literally told those words to her.
Okay. So I don't have the slightest idea where to go from here. What's your position on intervention?
Well, Your Honor, I don't disagree with anything that's been said here in court. I think it's statutorily hard to say that the defendant qualifies for it if there aren't any drug or alcohol problems or mental health issues. However, maybe there are some that we're just not aware of. I don't know. Perhaps the defendant could speak again with Lake Geauga or the probation department to shed some clarity on these issues.
All right, here's what I'm going to do. In order for you to convince me to devise an intervention plan, you're going to be re-interviewed by Ms. Friend. And you are going to discuss with her in complete honesty any past trauma, any past abuse, so that I know that when you come back here. So, Ms. Knaus, I would like Ms. Friend to perform this task immediately so that I can bring Ms. Riley back here after having been informed of the source and extent of the trauma or abuse, so that I can do something that is going to benefit you in the long run, instead of pushing you through the system where sure as shit you would end up back again. That should be your goal. Whether it is your goal or not, I don't know. But if it is your goal, you can't attain that goal without addressing what the problems are. So if you could have Ms. Friend contact Maria and say when, beyond immediately, this report will be done so we can get Ms. Riley back here and figure out just what the hell we're going to do. It's on you to be honest with them, okay? There has been, despite what you say in the pre-sentence report, there's been no accountability. The avoidance of accountability started on May 25th when this arrest happened and has been going on ever since, okay? Accountability means being completely honest with what happened, how it happened, why it happened. And for your benefit, I hope Martez Brown is in jail for a long time, because he's certainly of no benefit, or other people like Martez Brown that you've been hanging around with for too long. Nobody in the traveling dancing business gives one shit about you. They care about how much they're going to make off of you. I don't know if you realize that. You may make some money off of it, but they're making money off of you. They're using you for whatever purposes they have. Guys like Martez Brown and every other slug who's there to take his place now that he's in jail. So you go back and talk to Ms. Friend and we'll meet again.
All rise.
All right, we're still live. We're still on the record, and we're ready to address the matter of People versus Stephen Ray Kaufman. File number is 251634FY. Mr. Kaufman is here with his attorney, Ross Truckee. Also present is Angelique Camfield from the prosecutor's office, and Nicole Hagaboo, formerly Nicole Sigler, is also present. She's here with us by Zoom. Mr. Kaufman, I appreciate your keeping us apprised on what your traffic difficulties were, and I appreciate you getting here on time in a snowstorm.
Barely.
Yes, well, you're here, and that means you take the matter seriously. You were charged with aggravated stalking, which is a felony, and you entered a plea to a misdemeanor charge of stalking. That plea was entered on December 2nd. I set the matter for sentencing for today. I wanted to get more information about the matter and make sure that Ms. Sigler had an opportunity to be heard on this. And so here we are. So I'll start with you, Mr. Truckee. What would you like me to know?
Thank you, Your Honor. Around March of 2025, the wheels fell off for Mr. Kaufman. He found himself facing a divorce, a change of scenery, cleaving a part of a relationship that he'd been invested in, and he did not handle it in the way that society expects or requires for adults to handle those situations. He had a very hard time kind of accepting his former partner's change in position, and he acted out. He was harassing, and well, he pled to this charge. He pled to the stalking charge. He repeatedly contacted her. A PPO was issued. There were violations of the PPO. Mr. Kaufman did not comport himself well during this time, and it's my belief that he's rather humiliated by this and the way he acted when he was in that situation. The saving grace, if we can call it that, is that at some point he was arrested at the end of March, lodged, and got the brakes slammed and got shook up a little bit. He ended up on felony probation that he's been compliant with. It's my understanding that there's been no further conduct since the end of March of this year. So that little bit of intervention by the state's power was able to kind of shake him out of his negative situation and his obsessive behavior and allow him to try to regroup. So here he is trying to regroup. He's made his court appearances. He entered a plea in this again. He's done some jail time between this case and a resisting case and a larceny case, all of which really did kind of orbit around this divorce. I would ask that the court consider time served and fines and costs. I don't know if the court would want to duplicate a probation period because he is on felony.
I do have a concern about that, doing 2 probations. But we'll see. I do have a question, Mr. Kaufman. At some point, you were in the LaGrange County Jail back last February. You got served with this PPO while you were in jail on LaGrange. What were you in jail in LaGrange County for?
I got pulled over for illegal tags. My tags were expired, and I got caught with meth, and I had some guns with me.
Are you done with everything in Indiana?
No, I'm supposed to go to court next month for that.
So that hasn't yet been resolved?
No.
Have you pled?
They offered me a plea deal that I was gonna accept. We just haven't it got postponed until January.
All right, so you're going to LaGrange County in January?
Yes.
All
I
right.
don't remember the date offhand, but it's coming up. I know that.
Okay. All right, Ms. Campfield, what's your thought here?
Well, Your Honor, I know that the victim does wish to speak to the court, as the court's already indicated, but this is an instance, even though it was reduced to a misdemeanor stalking, the communications and contacts were in violation of a personal protection order that was obtained She did fear the defendant. She still fears the defendant. There were, by my information, over 31 separate contacts made that violated the protection order, texts, phone calls, driving by the house. And I know she feels that she and her children are not safe because of the defendant's stalking behavior. And it got to the extent that he even cut the Wi-Fi line to the house so that the cameras, the security cameras that were on the yard and driveway and whatnot were not operative, so that he could come to the home unaware for the residents. That is very concerning behavior. I don't think that he is safe, and I don't think that it warrants just a fines and costs as the defense has requested. I would like to see frankly, the maximum jail on this. And then he can go to LaGrange and deal with the potential felony offenses there.
So you're asking for a 1-year sentence?
Well, Your Honor, I guess I would be willing to do less than the 1 year.
Well, let me ask this.
Maybe 6 months because of the continued nature of the contacts and the length of time over which it occurred. And these things were not just observed by the victim and people that she knew. There was an officer present that observed this behavior as well.
And he made the arrest then in August. But if it was that urgent, why did they go from March 27th to August 4th before they even authorized it? And then another 3 months before they served the warrant.
Your Honor, I'd also like to place an objection regarding the cutting the Wi-Fi. There's not been a finding that defendant engaged in that conduct.
Oh, well, those were allegations, I guess.
Well,
I know we didn't have I don't think we had a PPO violation hearing. I was always troubled by the delay between the conduct and the charge, and between the charge and the arrest. Because as far as I could tell, nothing has happened since March of 2025, or at least early April. The defendant bonded out of circuit court on April 8th. And then this didn't get authorized until August 4th. So we have April, May, June, July, 4.5 months where apparently nothing happens. And they get the warrant, and it doesn't get served, and he's on probation. It should have been very easy to find. The R&O charge was dismissed, and he pled to uttering a publishing case. He's on felony probation, and now the prosecutor asked me to give you a year in jail, and I'm trying to reconcile all of that.
Well, Your Honor, I don't know the reason for the delays, and there was further investigation requested for body cam and digital evidence, in addition to probably the number of communications having to be put together in order for this to rise to a level of a stalking offense being requested. But I don't think the delay negates the defendant's prior conduct, nor do I think that the delay negates the fact that since he hasn't done anything since April or May, that he should just get fines and costs for this. This is an instance in which he was repetitively violating a court's order and placing this victim in fear. Yes, I'm grateful that he hasn't done it since he was put in jail for some of it. However, I think that he should receive more jail, not only as a punishment for the behavior that did place this victim in fear, but as a deterrent to others that we've seen in this community that do keep repetitively violating this court's protection orders. Not only bond conditions, but personal protection orders.
Well, they never, as far as I can tell, had a hearing regarding violation of the PPO.
Mr. Kaufman does report he was held on a PPO violation, but I'm unsure of how that resolved.
I got 3 days served for it.
All right. I don't know.
I mean, I guess if he's not going to be on supervision here, and he's most likely going to be on supervision in circuit court for a little bit longer, or in LaGrange County, and this court's not doing a probation with respect to this particular behavior, that is all the basis for my recommendation of a pretty lengthy jail term.
Well, one problem, if I put him in our jail, he can't go to his hearing in LaGrange in January, which is probably going to result in a jail or prison sentence in Indiana. If I put him in jail here, it's going to delay his court appearance in the state of Indiana. And that is causes issues. Well, Miss Sigler, Miss Hagabo, you've been here listening to all this. I appreciate your being here. I'm glad you didn't have to drive here in a blizzard. What would you like me to know?
Well, I wrote the letter to you. And then I've previously filled out the victim's rights form. I just want this resolved and I want him to stay away from me and my family. I don't know if I know he hasn't texted or called, and I don't know if he hasn't drove by the house. We didn't know what he was driving until the last court date, but I just want him to leave us alone. And I want him to get something out of it because he had said several times that he didn't care what the court said or the cop said. He was going to do what he wants. And even Ali answered the phone several times when he called, and he disregarded what Ali was telling him. And he disregarded what Bill Burgoyne was telling him also.
Well, in your letter, does everybody have her letter of December 3rd?
I do.
Yes.
All right. I was going to ask him about this. There's a pink elephant in the room, which is methamphetamine. And people do crazy stuff on methamphetamine. Now, you two weren't actually married, were you?
Yes.
Okay. And at what point were you divorced?
I think it was April.
All right. So I guess I knew that. And as you noted, I did your most recent wedding here at the courthouse. So you were still married at the time this was going on. And subsequent to that, in April of 25, you got divorced.
Right.
All right. Has he contacted you at all since the divorce?
When I filed divorce, it was in March. And when we were in the divorce phase, and that he was still in jail. So the whole divorce proceedings happened while he was in jail.
And where were you divorced?
In St. Joseph County.
All right. Okay. So then once he got out of jail, you were divorced?
Right. I believe.
All right.
Yes.
And have you had any contact with him since you were divorced?
No.
Okay. All right. And basically, you've got a new marriage. You want to just go on with your life and have him stay away from you and your family. Is that correct?
Right.
And you and he do not have any children together. That's also correct?
Correct.
All right. And the things that Ms. Canfield spoke to in her statements come directly from the victim impact statement and that letter of December 3rd about all the travail that they went through as a result of this. All right. Having said all that, Mr. Kaufman, I was going to ask you about methamphetamine. You're on probation right now to the circuit court. The resisting and obstructing charge ended up getting dismissed, and you're on a uttering and publishing charge, which is kind of a strange, not related to any of this. Are you on testing conditions with your probation agent?
Yes.
So when did you last do a drug or alcohol test?
It was the last time I reported.
All right. So
I don't remember the date. It was this month.
Things got better when you stopped doing meth?
Oh, yes. Yes.
All right. Ms. Singler, I don't know if I cut you off. You did share your letter, which was well written. You had your victim impact statement, which I also read. And so this conduct happened in March. He went to jail. You got divorced. He never had any further contact after the divorce. The warrant issued in August. As Ms. Camfield stated, sometimes it takes a while to get all the information together. Then it didn't get served until 3 months after that in November. So between March 27th and the time he actually got arrested, there had not been any more misconduct. He posted bond on the attempted R&O, I think on April 8th. No, on the uttering and publishing. It looked like the other case, the attempted R&O, he didn't get out till it was dismissed on the 20, on a subsequent date. So it looked to me like he had 12 days plus 17 days for 29 days jail so far in this case. I think I have a plan here, but Mr. Kaufman, I didn't let you finish either. What would you like to tell me?
Just that, you know, I've lost everything since I've done all that. I haven't denied anything I've done. And like her, I want to move on too. You know, I haven't went around her or the house. I haven't drove by the house. I haven't contacted her. I'm ready for this to be behind me. I'm not proud of it. I apologize to her. I apologize to everybody here for having to go through this too. I'm just ready for it to be over with. I gotta go through my LaGrange stuff now.
Yes. Well, I don't want to put you in jail and have you miss your LaGrange County dates coming after the first of the year. So I'm going to do a 6-month probation. I'm going to order 90 days jail, credit 29, leaving 61 days to serve. Of the 90 days ordered, 61 are deferred. So you're not going to jail. I'm going to do a probation, double probation, but the only condition is, well, there's a couple, no drugs and no alcohol. Report for all LaGrange County requirements. Proceedings, we'll call them. No drugs, no alcohol, no contact with Nicole Hugaboo. No contact. The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. That's $375. Excuse me, $275. I'm not going to put you on a probation oversight fee because you're already paying a probation oversight fee to circuit court. And you're right, you owned it. You didn't deny it. It was bad. Miss Campfield's right, and Miss Hugaboo's right. It was bad. You're on a probation here in St. Joseph County on a circuit court matter. Your drug testing, there's probably a condition you not have any contact in that case. So there's no sense doing all that here, but I'm going to do a provision that you not have any contact with her. You report for all of your LaGrange County proceedings. If you end up being sentenced to a jail term or worse in LaGrange County, I can discharge this probation. But I want something hanging over your head until that's completed. So my probation department's going, what am I supposed to do? But I'm gonna also say comply with circuit court probation. That $275 is going to be due by March 1st. This is a 6-month probation, which theoretically could be terminated at the end of 3 months. I just want to control over it until your LaGrange County matters are resolved. To your credit, you haven't done anything since you got out of jail in April to violate either the PPO or any bond conditions. As Ms. Canfield said, that doesn't erase everything that happened before, but it's a good start. All right, if you do what I ask you to do, you're not going to do any more jail time. You take that downstairs to the probation department. And what I hope to hear about this is nothing. I hope you go resolve your LaGrange County matters. We don't have any further issues. Ms. Hogaboo, if there is any contact or any perceived violation of this, you contact the victim advocate at the prosecutor's office or contact our probation department immediately and somebody will take action. What I'm hoping is that it'll continue to go as it has. He goes on with his life and you go on with yours. All right. Anything else you wish to ask or state? All right.
So the people do have a question.
Yes.
We've now been made aware that during his bond for a stalking charge, he was arrested with the potential of possession of weapons and drugs. Just curious if that would be a potential violation of probation if he's convicted.
I don't know.
It preceded that. That happened in February. He wasn't, he was served with a PPO while he was in jail in LaGrange County.
Okay,
So it preceded all of this.
thank you.
All right. Thank you. Ms. Agaboo, thank you. Best to you. You're good to go. And
Thank you.
this record's completed.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right. Go downstairs to probation and they'll tell you what to do next. And good luck going out in the blizzard. All right. We'll be completed here. All right. Miss Spike is here. She was late, but she is here. She was actually here in the courtroom with me. And now they put her in the conference room, but she's been here. This is the case we can't quite get to the finish line. This is file 252403LT. I stuck this in here knowing I had all these small claims cases pending and that it probably wouldn't fit very well, but here it is. It's set for 2:45 today. We're quite a bit behind. Meg Bauer is here on behalf of Miss Spike. Miss Spike is here. As I said, she was right here in the courtroom with me, but now she's in the conference room in case she needs to consult with her lawyer. And Mr. Landman is here and Ms. DeCenzo, one of the owners of the park. We were close, but there were disputes about one thing or another. Defendant has been making payments into escrow. I will defer to you, Mr. Landman. What's the status here today?
Your Honor, when we were last before you, I believe that the two sides were $76 apart based on your calculations and based on what I recall being placed into escrow. The $76 amounted to the $40 late charges for November and December and the overage of $4 that was paid into escrow. If my memory serves me correctly.
Yes.
I think you adjourned the case to today to try to allow for a negotiated resolution rather than a final decision coming from the bench. That did not come to pass. There was a proposal made by Ms. Bauer a short time ago that required additional concessions on the part of my client and an extended timetable to pay, neither of which was acceptable. So at this point in time, from my perspective, we are waiting for a decision on the late charges for November and December.
Ms. Bauer, what's your position?
Thank you, Judge. The defense received no settlement offer from the plaintiff. So in an effort to try to get this off your docket, I did reach out to my colleague. That offer was summarily rejected, and so here we are. Ms. Speech attempted to pay her rent due on October 10th. She went up to the store to pay on October 17th. She attempted to pay on October 24th. She attempted to pay on October 31st. She attempted to pay, including November's rent, on November 4th, November 7th, and November 14th. That's 7 efforts that Ms. Speech made to pay her rent, to pay all of her rent. And the plaintiff rejected those efforts. The plaintiff is now asking you, once the plaintiff rejected those efforts, she had no option but to ask for an escrow order so that she could put her rent into the court's possession. Now the plaintiff is asking you to give it a judgment of, last time the ask was for $79.76. Today it's $76, regardless. The plaintiff is asking you to enter a judgment of $80 in its favor because its client, or because it would not take Ms. Speech's rent on 7 different occurrences. Ms. Speech was not late on her rent in November. She was not late on her rent in December, and she attempted to pay her rent in full on October 10th, a mere 5 days after the deadline. So, in the absence of a willingness to collaborate, Ms. Speech does object to any award of any late fees, October included, on the grounds that those clauses in the contract are unenforceable penalty clauses. The Michigan court has set out a 3-part test under Roland v. Kenzie. It's a 1968 case. If a liquidated damages clause is going to be enforceable, it must satisfy 3 conditions. Parties seeking recovery must suffer real, substantial damages as a result of the breach. The damages must be uncertain, and the stipulated sum must be reasonably related to the injuries that may result from any breaches to which it is applicable. In this case, the plaintiff has been seeking $175 per month in late fees until we showed up at the first hearing when they indicated, well, we'll take $40. There is no injury to the plaintiff because Ms. Speech has been attempting to pay her entire rent plus some since October 10th, and they have been rejecting it. So we are talking about lot rent that is $440 and a late fee that is originally almost half of her lot rent. We have heard no evidence or testimony on the actual damages that the plaintiff incurred as a result of Ms. Speech attempting to make her payment on October 10th instead of October 5th. And Ms. Speech can provide testimony to support the statements that I've made, that she's actually made 7 independent trips to the store because they won't take payment elsewise, to attempt to pay her fees. She then had to contact legal aid, get legal assistance in order to get a place to pay her rent. And she's being punished. She is being punished for trying to pay her rent, trying to be a good and diligent tenant. And the plaintiff is asking you to continue punishing her and allow them to continue to pursue their frankly egregious practices of forcing tenants to pay $175 in late fees or come to court. So the defense objects to any award of late fees and ask this court to dismiss this, release the escrow to the plaintiff and dismiss plaintiff's claim as paid in full through December 31st.
In response, Your Honor, a couple of things.
Yeah.
Firstly, Ms. Bauer concedes that her client paid late in October. So the issue of an October late charge should not be in dispute. Secondly, the payments that were attempted by the tenant were not payments in full. The lease that was signed by the tenant, agreed to by the tenant, explicitly provided for a $175 monthly late fee. Under Roria versus Continental Insurance, the Michigan Supreme Court has held and it's been cited over and over and over again that the words of a contract are to be given their plain meaning.
That's not a landlord-tenant case.
I
It's
agree.
not
It's not a
under the
landlord-tenant
Summary
case.
Proceedings Act. It's not under the Landlord-Tenant Relationship Act. And
But a
Ms.
lease is
Bauer
Your
stated
Honor,
the quintessence-
case law is clear that a lease is a contract. So the bottom line is that your policy is, at least until January 1, was $40 a month for late fees. And my client changed its policy based on what you have indicated would be awarded. My client will change its policy again based now on your indication that as of January 1st, $50 a month for late fee is what the court will award. So there has not been an evidentiary hearing on the issue of penalty versus necessity. Ms. Bauer suggests to you that there's no evidence, but there hasn't been an evidentiary proceeding that has been scheduled by the court to address that. I'm assuming such an evidentiary proceeding would be in person since the court prefers it that way. As far as the amount, Ms. Bauer may be correct. It may have been $79.76 versus $76. It depends on the amount that's been paid into escrow. I don't know the date that the November payment was made into escrow, except I'm sure that it was after November 19th, which was when the escrow order was entered. And again, we've already discussed ex parte versus having a hearing on the issue, and I'm not going to revisit that. It should not have been entered ex parte, in my opinion. But the payment was made late in November, even into escrow. The motion for escrow was filed after November 5th. I believe it was filed November 14th. December's payment, I don't know when it was made into escrow. If it was made into escrow after the 5th, certainly it was made late. But again, the bottom line on the whole thing is that the October payment was made late. It wasn't paid in full. The offered payments in November were made late because they didn't include any late fees at all. And then it was paid late into escrow. So my client's position is unchanged, and I believe Ms. Bauer's argument is flawed.
She stated one of the quintessential cases on liquidated damages.
I'm on a Zoom court hearing.
Mr. Mauer, pretend like you're in court, all right?
Oh, I
I'll
apologize.
put
I
you in the
didn't
waiting
know.
room. You can talk to your friend and we'll come back to you when we're ready to deal with your case. So let me put you in the waiting room. And the law is not clear, but it's supposed to be related to something, some loss. For those of you who are waiting for your small claims case, I apologize. I'm the judge and I stuck this in here. We're fighting about $76, and so far we spent several hours fighting about $76 as it boils down to it. We can't quite get where we need to be. My hope was that they would reach a settlement and this would take 2 minutes instead of an hour. What they're proposing is an all-day hearing regarding how much the damages actually are. How much does the plaintiff suffer from the late fee being late? And as I stated, I didn't think I could find a judge in the state that would allow a $170 a month late fee. And I don't appear everywhere. Mr. Landman does. He said apparently some judges would. There are some judges that allow no late fees. I started at 25, went to 40. I'm at 50. This is lot rent, not even the apartment. So I tend to wonder how they'd suffer $175 worth of damage for not paying their lot rent. But I'm not going to expend any more emotional capital on this. You guys can appeal me over $70. I'm going to take out the October and November, the November and December late fee. October's payment was late. First attempted payment was October 10th. I'm going to take out $80. There was a $4 overage. And I believe there's enough money in escrow to pay the arrearage. It was a 79.76 difference is what the difference was. We had $1,659 in rent and $1,580 in escrow. I will take out 2 late fees. So that leaves us 4 cents off. Through December.
Your Honor, the total also doesn't include the 170.05 in court costs.
Yes, it costs,
Right.
which is 1,829. So I'm going to take 1,659.76 minus 80.
Judge, you said 1,000.
1,659.76.
Minus.
That equals 1,579. She has 1,580 in escrow. But there are court costs of 170.05.
Judge, if you were to enter a judgment on the judgment amount, her judgment would be negative $1.
That's incorrect.
You're asking her to pay $170 filing fee and court costs on a $1 judgment in her favor.
No, the judgment amount is $1,579.76. The costs are $170.05 for a total of $1,749.81. And then the judgment would provide that the amount being held in escrow should be paid to the plaintiff, which would reduce the judgment balance.
Correct.
I would also like to point to the plaintiff's lease. Since my colleague would like to hold on to the terms of the contract, paragraph 34 addresses attorney's fees. As we know, attorney's fees themselves are not awardable under the statute except as set by statute, so those are in violation of the Truth in Renting Act. And the contract provides for a 15% fee. So the tenant agrees to pay all costs of collection, including 15% of the sum collected as attorney's fees. So 15% of the amount you're about to award
is far more than the statutory attorney fee of $75.
Except that she has paid her rent into escrow. She is paid November on time. She paid to the extent that she was able to. She paid including a $50 late fee. On November 4th, she paid $50 for October's late fee, plus her November rent, but it was still rejected. And then she paid December into escrow on December 4th. On November 4th, Ms. Speech attempted to pay $1,078 to the plaintiff, and the plaintiff rejected it. That is $50 more than the plaintiff was entitled to for November, through November 30th.
Again, Your Honor, I would state that the $75 is permissible by statute and it is appropriate in this instance.
I agree. Even though it was a negative $1, there was a original late payment which instituted the case. So plaintiffs entitled to their court costs. Escrow funds may be released
Judge,
to the plaintiff.
will you extend Miss Speech's redemption period based on the fact that $170 in costs and fees is 50% of her rent. This award of court costs and attorney's fees is very likely, if exclusively court costs and attorney's fees, is very likely to render her homeless if there's not an extended redemption period.
Your Honor, I believe that January 8th should be plenty of time for Ms. Speech to come up with this amount. January's rent, of course, is due on the 1st.
And Judge,
Yes.
we are not fighting over $80 simply on principle, but as you know, the demographic of clients that I represent, every dollar makes a difference. So we're not trying to be difficult. What seems like a couple of meals for one person is a substantial portion of that individual's entire monthly budget.
As I indicated, we've been at this since October, I think. They are entitled to their court costs. They were compelled to file the case. We did try to whittle out as much as we could. We tried to spend a lot of time doing it. That's my order. $1,579 through December, 170.05 in cost for a total of $1,749.81. The escrow funds of $1,580 may be released to the plaintiff. So you owe $169.05, Ms. Speech, to be current by January the 8th. Mr. Lamon, if you would send me an order.
Your Honor, I will do that.
Judge?
Yes.
Advice, this case could have been mitigated if the law firm seeking to collect these fees had advised its client of your policy and what it would accept in fees. And this will subject Ms. Speech to the perpetual late fee cycle because they will not accept her money unless it also includes rent for all of January at the same time. And so she will be late again.
And that's an issue. If it's a non-payment of rent case, they have to accept payment of the rent. They can't only accept payment in full. And so that's an issue they may need to deal with.
This is a non-payment of rent case and they have rejected.
Yes, I understand.
Okay.
I don't have any more time to spend on this. I've got 10 litigants in 5 cases waiting for their small claims cases. So I've made my ruling. Mr. Lamon can submit an order. Ms. Speech, I keep mispronouncing your name, I'm sorry. You owe the court cost minus $1. You've done an excellent job of paying the money into escrow. That money will go toward your rent. Heaven forbid, we could have a hearing one day to determine what their actual liquidated damages are. They're not $175. But I try to be consistent across the board, and we'll go to 50 as of January 1st. All right, that completes this case. Ms. Speech, I don't have an order to give you because I don't have one from Mr. Landman yet, but he's going to email me one. We'll get one to you as soon as we can.
Judge, I'd also like to state for the record that it was represented at the last hearing that all of the tenants in the park were notified of a change in the policy, and I've spoken with multiple tenants that received no notice of such change. I understand that you are done with this case.
We haven't had a case yet, so I guess we'll see. We may need a hearing. It would take a day to figure out what their actual liquidated damages are, but we don't have time to address that right now. All right, thank you all.
All due respect, Judge, that is not my client's fault.
All right, thank you. All right, we'll see where this goes. Miss Speech, I hope you can make that. Keep your tenancy and your trailer.
I can pay the rent. I'm not gonna be able to pay the $170 court cost by January 1st. I mean, come on, I'm a cashier. I can't.
Then I don't have an answer for you. They're entitled to those fees. All right.
And we try
This
to.
is your last landlord-tenant case.
All right.
Judge,
That's the last one. Everything else is small claims.
thank you, Judge. Have a good rest.
All
Have a
right,
good
thank you. All right, thank you. All right, thank you. Now we're down to 2 cases. And one is a $7,000 claim and a $7,000 counterclaim. That's Bittner and Pianowski. We'll come back to that one in a minute. But let me tell all of you who are here for small claims court. My name is Judge Middleton. I'm the district judge here. I took over Judge McManus's bench 24 years ago. The rules are pretty much the same as they were back then, although the amounts have changed. In small claims court, you can sue for up to $7,000. Neither party is allowed to have an attorney. There's no formal record being made in small claims court. And there's no appeal. Any decision made here today is final. Either party has the right to ask to remove the matter from small claims to the general division of the court, where you can sue for up to $25,000, have a lawyer, have a right to appeal. We had a case this morning where that had happened. The defendant removed it. Anyway, once we begin here, any decision is final. Ms. Metzger, you understand?
Yes, sir.
Ms. Terry, you understand?
Yes, Your Honor.
And Mr. Ruffkin?
Ruffin, yes.
All right, I'm going to ask each of you, Ruffin, if you would all please raise your right hand. Do you all swear and affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes. Yes, sir.
All right, the defendant lives in Florida and she rented a property in Sturgis. And it looked like a nice property, but it looked like it kind of got trashed. The plaintiff's claim is for $6,000. Plaintiff claims that there was a tenancy for about a year, October 1st of 24 through October 1st of 25, at 2101 Cottage Street. They left the property in damaged condition. They removed a built-in double oven, and the pictures are hard to look at.
I know, I apologize.
Detached and took the matching upper and lower cabinets, drawers, leaving the kitchen layout incomplete and damaged. Multiple windows and screens were broken. The property was filled with excessive trash and debris requiring professional cleanup. I'm seeking reimbursement for the cost of cleanup, repair, and replacement of the removed and damaged items. Is that correct, Ms. Metzger?
Yes, sir.
All right. I read these last week and I read them again this morning to try to refresh my memory on them. Ms. Terry, what's your position, Mr. Ruffin?
Your Honor, Ms. Metzger rented us the home. She was supposed to buy a new oven because that oven didn't work. Ultimately, we had to replace it. She was aware. She agreed. She never paid me back for it. She sent me an email that stated that she was sending somebody to paint or do some work to the outside of the house, paint the outside of the house, which had been done before we moved in and had been done a couple times because it kept flaking. The pictures that you see, she did send to us, but she didn't give us an option to do anything with it. We had both been working. The tire was removed immediately. It was just sitting outside the garage. We had took it out of the back of the truck. It was removed immediately. She threw away the rest of the cabinet, so we couldn't put it back around the oven. We paid for the oven to be installed. We paid for everything to be around it. We paid for plumbing that she was supposed to pay back that she never paid back. Like, it was just a nightmare renting from her. So this is really a bogus claim. There wasn't any windows broken when we moved out. There wasn't excessive.
All right, well, let's back up. There's probably enough nightmare to go around. Mr. Bittner and Mr. Pianowski, welcome to small claims court. This is going to take us a while, but I spent about an hour arguing about $76. All right, Ms. Metzger, let's take your testimony. Why do you believe they owe you $6,000?
Your Honor, this claim is for a tenant caused property damage beyond normal wear and tear.
While Demetrius and Samantha were tenants at my property, they removed and discarded the built-in stove.
Yeah, well,
and
let's
caused-
add up the numbers. Let's see how you came to $6,000.
Sure. Are you wanting me to do that, or you didn't know if you're going to read something? The
Well-
$4,000 was quoted from my contractor to clean up the remains of the cabinet that was just discarded outside by the back door of the kitchen. That's what one of those photos is. That was the built-in part of the oven.
All right, so $4,000 of this is for the removal of the cabinet and the oven.
Well, the oven alone cost $2,200, and it was in perfect working order when they moved out. I was not aware that they had replaced until after they had done so, and they were actually wanting to purchase
All right,
the
well,
property.
slow down a little bit.
Oh, I'm
You
sorry.
said the oven was in working condition when they moved out.
Absolutely. I mean, not when they moved out. When I moved out, I apologize.
All right, when they moved in is what you meant to
Yes.
say.
Yes.
All right, so the oven, now there are some pictures before they moved in. Your dog's in them. He looked
I
happy
know.
to be there. But everything looked clean and neat and a nice looking kitchen and a double oven. You're saying at the time they moved in October of 24, that oven worked.
Yes, sir.
Did they ever tell you that it did not work?
No, I was notified on my way to Las Vegas months later that it was for me not to worry because they had already removed it and got somebody by the name of, his name was Logan, a child that's going to school to be an electrician to install it. Unfortunately, when I came after many attempts to go inside of my own home, I was denied until they moved out. That's when I had unfortunately found the replacement that they gave was on 2x4s, not built in, and the door to the kitchen barely even opened. It scraped against the oven because it was too big for the area. They did try to replace, but at the same time, the built-in part of it is gone, and I had to replace it after they moved out because that one didn't work when they moved out. And I know that the previous oven worked because they just discarded it in my home after they left. It was still in the home. So
all right, well,
I
let me see if I can screen share here.
Go ahead.
Well, I don't want to share. That's a really nice picture of the Grand Hotel.
It's beautiful.
But that is what I was trying to share. All right, that's the oven that was there in November of 2021.
Which is the same oven we're referring to.
Is that where it was and how it was situated?
Exactly.
And that was July of 2015, according to that picture. So you're saying on October 1 of 24, when they moved in, that double oven was there?
Yes, and fully functioning. And I have zero report of the tenants asking or telling me that it didn't work. So even if the stove stopped functioning, it was built-in fixture and part of the property. And to me, the tenants are required to report the maintenance issue, not to remove it or discard it.
Is that what they replaced it with?
Yep.
So when you got into your apartment, that's what or your house, that's what you found?
Yes, unfortunately.
So the cabinet was removed and that was there in its place.
Yep, and that door that you see to the right could barely open and shut because that unit is too big for that area.
All right. Ms. Terry, what do you say to that?
Okay, so part of what she said is correct. The oven is original to the house, the one that was there. It did not work when we moved in. She was aware of it when I called her and told her. she said, yeah, that thing doesn't, what was her words? It doesn't heat properly, it doesn't heat evenly. That was her exact words. So we were unable to use it to cook. And so she then told me that it would be replaced. She never got to replace it. I called her because I was at a store. I told her about that, and she told me that to go ahead and replace it, and she would pay me back for it. I did use Logan at her suggestion. I didn't know Logan before I knew Lindsay. She introduced me to Logan, which was the person that we paid to replace the oven. She was aware that the cabinet had to be replaced because you can't find an oven that size, or at least I couldn't. I did try because it was the smaller ovens, and I couldn't find one anywhere. So I went to several of the appliance shops, and I ended up buying one in Niles. And that's the one I bought. That one was working. That is a $6,000 stove. That is not what I paid for it. I paid $600 for it. And then I paid $250 to have it installed and $150 to have the electrical installed correctly, because it wasn't installed correctly either. And then Logan was going to come back and put the cabinet up. But again, Lindsay sent her people over and had the cabinet thrown away because we were going to build the cabinet around the stove.
I don't know if she's referring to the cabinet that was discarded outside, right outside the door, but that was way in different timelines than she's referring. That was already molded, and as you'll see in that photo, had been laying there for a very long time. And I did not tell her.
There's a tire outside the house.
Yeah,
these photos were taken just days before they moved out. So nothing was done quickly.
Actually, I have the message, and you sent that over a month before we moved out.
What message?
All right, well, hold up a minute. All right, these were taken, it would have been in September of 2025.
Yes, this was the first time I was denied access to the home. I had everybody take photos as they walked around. And that was the condition of the home.
And that's the back of the house?
Yes, sir.
But Your Honor, the
just a minute, I didn't ask anything. What are we looking at here?
That's my built-in barbecue.
That's the sink for the outside, which was broken when we moved in. We were told
it was cracked, not broken.
All right, well, hold it. I'll give you a chance to speak. This is her turn.
And that's the cabinet she's referring to that I threw away in September. But if you look back and she even wants to tell you, if I knew about this, there's no way I would allowed that to be out there. Yes, so in September I did remove that because clearly it's been out there for a long time and not.
So you threw it away because it was laying out and that's what it looked like when you found it in September of 25.
That's exactly what it looked like. I didn't know what that was a part of. I just thought it was trash because I told them to clean it up. They didn't, so my contractor had to because I was selling the home.
Go ahead, Michi.
Your Honor, before I
just a minute. We're at a court trial. She's testifying. I'll give you your chance to testify. I say often, we're not sitting around the kitchen table. You're all under oath. She's asking for $6,000, and this is her telling her side of the story. I'll give you a chance to tell your side. This is some other stuff that appears to be junkified on the back patio.
Yep.
And are all those pictures fair and accurate pictures of what the property looked like in late September of 2025?
Yes, sir.
Just before the defendants vacated?
Yeah, but right before I evicted them.
All right, what's the camper outside there?
That was mine, and I got that removed. Is because when she had moved in, she had made the claim that she wanted to purchase it from me. So she actually had the keys to that unit. And it wasn't until my contractor, his name is Travis, that you'll see the estimate from, actually got the key back from Demetrius after numerous times of me trying to reach out to Samantha. That was unsuccessful. So while Travis was there, he got the key back from Demetrius, and I was able to remove that unit from the property.
I'm scrolling through the lease. There were some other. Oops, it must have been another exhibit. I'm going to stop screen sharing. All right, so there's a fundamental difference. Your testimony is that the stove worked when you got it, they rented it, they removed it without your consent, made it look like that unsightly thing that was there. Her testimony under oath is you knew it was broken and recommended the installer to do the installation, and she had him do it, and then you knew she did it. So what's your response to that?
That's 100% false. And not being able to find the unit in the same size, I did. And that's why that quote is for $2,200. And that's why I was so upset, because they're not cheap units to replace. I would never allow someone to take the integrity of my kitchen apart to replace with something, even if it was more expensive, but one that didn't fit into the space to begin with. Those units are about $2,200 to $2,600 because it's a 24-inch unit and it was replaced with a standardized size. That's why it didn't fit.
All right, so $4,000 is the removal of the stove and the cabinet. Where's your other $2,000?
So the $4,000 is really mainly for the outside. That's from my contractor, Travis, cleaning up all of the debris outside. I had to get a trailer to remove not only all the weeds and all of the stuff that they had out there, but cleaning up the property, getting it ready for
I didn't
resale.
see $4,000 worth of damage in those pictures.
That's
I saw
just the-
some things that looked kind of shabby, but
Yeah.
maybe there's more that I didn't see. But I didn't see $4,000 worth of damage. Let's
Yeah, the
find
amount
your.
Yeah, I hope that you have everything, but the amount requested is just based on the actual replacement cost and the contractor invoices. These are definitely not estimates or speculation.
Well, I'm looking for, I don't actually have paper copies of these small claims cases. They're all electronic. I have to go on a scavenger hunt to find what I'm looking for. I'm looking for your, all right, there's the 24-inch double electric wall stainless steel, $2,378. Did you actually purchase that?
No, not yet. No, right now I have an
And-
apartment size oven in there just so that the door could open properly.
All right, then you have Witterlock Property Solutions, $4,000, October 3rd of 25. Clean yard and backyard peaks paint, 1 times 1,000, side peaks paint. That's not theirs. Paint materials, roof ridge materials, $4,000. So that's cleaning up the yard and paint the back peaks. That's not $4,000 of damage that they're responsible for.
No.
So how much are you asking for the cleanup?
So the contractor, Travis, he had basically quoted me just $1,000 for the weeds and all of the stuff out there. And then I had him paint an additional because I was trying to sell the house. But then I really need the oven to be replaced. And then I need to fund the contractor to install it properly and make it look as best I can.
All right. All right, Miss Terry, Mr. Ruffin, this is your chance to tell your side of the story. So, Miss Terry, I'll let you go first, then we'll hear from Mr. Ruffin.
Okay, Your Honor, I've given you most of it. I'll try not to repeat it. She sent us pictures of what she wanted done in the yard, but she told me that somebody would be out there the next day and for me to leave it alone.
Well, you vacated on October 1st, and that quote is dated October 3rd.
No,
So,
no, she had people out there doing it with us still living in the home.
all right, well, very close in time to the time you left.
It was a month.
I didn't see
earlier.
$1,000 worth of repair out there, but maybe to paint it. But all right, so there's that. Now the stove looks like hell. You can clearly find a comparable stove. You got some secondhand model for $600 and mounted it on some rickety 2x4s. That wouldn't have passed code the city had come in to look at that, they would have not allowed it to happen. That's
It wasn't registered.
220 wiring. And then she doesn't know what happened to her stove. She
Her stove was
says
sitting in the
she
dining
didn't
room.
give you, say that again?
The old stove was sitting in the dining room. Because
On my beautiful floors
it wasn't scratched.
that you know of.
All right, so you still got the original stove. Is that correct?
It's now been discarded because it had sat wherever it sat for as many months as it did. So I didn't try to I can't put it back up without a cabinet surrounding it. So.
All right, so she took your stove out and replaced it with hers. She said it didn't work. So let's assume it didn't work, and I will assume it didn't work, because why would she junkify it like this if it did work? So she has to buy you a new stove because she took your stove out. She didn't throw it away. She simply parked it there inside the house. So you threw it away, and you want her to buy you a new stove. She also left her funky $600 stove in there. So there's some compensation to be made, but I'm not sure what the amount is. All right. And they tore the cabinet out of there and threw it out in the backyard where it got warped and water damaged, and then you threw it away. You can't expect her to want to save that cabinet after it was laying out in the yard like that.
You're right,
Now,
Your Honor. I didn't
all
expect it, but I did expect to have that so that we could use the dimensions to build a new cabinet.
All right. Now, what about the cleanup?
We would have done the cleanup. The only thing that was done was that pile of the cabinet, and we removed the tire. The camper is a whole different story that I won't get into because it's not part of this case, but it was removed. And the sink was something that was broken when we moved in there, that plastic sink in the outdoor kitchen. And we were told not to replace it because the homeless would just break it again. The only other thing laying there is the umbrella because we were taking down summer stuff.
Yes. The $4,000 quote she got from her contractor includes a bunch of other things that didn't include your cleanup. Now, was there an actual landlord-tenant case filed? I didn't see one, or you simply moved out because she requested that you move?
She didn't request. I gave her a 30-day notice and I moved. There was no eviction. There was no nothing.
Eviction papers were already filed. They were already filed. She moved out before it was finalized.
All right, let me look at it. I didn't find it.
I had stopped the process because she gave me the 30-day notice, and then I knew I was going to have to wait that 30 days in court anyway, so.
There it is.
And the cleanup was over 1,000 because of all the weeds that were all the way around my home. I was getting complaints from my neighbors that there were rodents now outside. So that's one of the reasons why I believe my contractor made it so much.
Was there a security deposit?
No, Your Honor, it was not.
Nope. Because they were planning on purchasing at one point and then they failed to do so. That's why a lot of that conversation has been a different in context. So I was never going to replace the oven because they were going to purchase it. I was never notified it didn't work. I was told that it was small. Yes, it's 24 inches. I made it work for the 6 years I lived there. And even if it didn't heat the same, it was an original model. So if it heated more in the back, I was aware of that. but I made it work the entire time I lived there. But I don't know. And it did not pass code. The new one did not, because I did have to have the city come in, and it is now determined as a rental with the city of Sturgis.
I'm looking at the lease to see if there was a security deposit. And it does not appear that there was one. Rent was $1,400 per month. Where did you get the lease?
I don't know. Honestly, I think it was just an online one. I don't recall, to be honest. It was over a year ago.
I've seen worse, but I've seen better also. I guess it was good enough, but there was no security deposit. All right. Mr. Ruffin, you had something that you wanted to say, and I cut you off. I said I'd give you your turn. Well, this is your turn. What did you want to tell me?
I said, I understand the mess. I work 12 hours a day and I got double knee surgery and I'm a little slow at doing a lot of stuff when it comes to doing the housework. That work stopped outside when we took the cabinet out to put the stove in because the first stove didn't work well. So we stuck it in the living room for her and we put the new one in. I understand the mess. Yes, the mess was a little slow for me to get to, and I was getting to the yard work too at the same time. Like I said, I work a lot of hours and I have bad knees. Well, they're good knees, but they're bad knees. You understand what I'm saying? I have, and I'm slow at it, but I was going to get to it. I kept trying to say, I'm going to get to the mess, but she had no patience. She sent the guy out.
Well, you gave them a 30-day notice to quit, meaning you had 30 days to know when you were
Yes,
going to
sir.
go.
Yes, sir. But all this mess she's talking about was done well before we was going to move out of the house. This was more than 30 days before we was going to move out of the house. This was just before the weather started turning bad. It was still in the late spring, early fall when all this came up with the mess.
Well, I agree with you there. It is a mess, but it's not a $6,000 claim. You took her oven out without her
Yes, sir.
permission and set it aside.
Yes.
Then she chose to throw it away. I believe her. You didn't have her permission to take it out of there, but I also believe you that it didn't work or you wouldn't have done what you did. And then to put it in correctly would buy her a brand new oven when the oven she still has, but it doesn't work.
Mm-hmm.
So also the cabinets were damaged. I'm going to allow $1,500 for the stove and the cabinets. And $500 for the outside cleanup, which is $2,000. If there was a security deposit, it could have been applied to these sorts of things. So I find for the plaintiff in the amount of $2,000. There are court costs of $102.50 for filing fees and a service fee of $115. The total is $2,217.50. Can you make some sort of payment each month on that?
Yes, sir, I can.
Judge McManus wanted everything resolved within 24 months. If we did it in 12 months, it would cost $200 per month. Can you pay $200 per month?
Yes, Your Honor.
Yes.
All right, judgment of pay to the plaintiff in the amount of $2,200 per month starting February 1st, 2026. All right, you make those payments directly to her. Is the Cape Coral address correct, Ms. Metzger,
Yes,
or
sir.
do you have it sent somewhere else?
Nope, Cape Coral address is
All
where
right.
I'm at.
All right, and you guys are in Niles?
Yes.
All right, I find for the plaintiff not in the amount of $6,000, the amount of $2,000 plus cost, $2,217.50 payable at $200 per month starting February 1st. That would pay this off in approximately 11 months, maybe a little more. All right, this matter is completed. We'll do an order and you'll get a copy of it in the mail. Send the payments directly to the plaintiff.
Thank you, Your Honor.
All right, you're both good to go.
Thank you. Happy New Year.
Thank you. All right, let's excuse those folks. Now we're at Bittner and Pianowski. Mr. Pianowski, you're in the waiting room or in the, why don't you just come right in the courtroom? It'll be easier for me to see you, and we often use that conference room if there's need to consult with counsel or something else, but let's have an old-fashioned hearing where you're in the courtroom. So come on in.
Can you tell me how to get there?
Yeah, just come out the door and come right here in courtroom C. Go out the door and go to your right.
Your Honor, for your record, my wife Emily is joining me. She is part of the suit as well. She was named as a plaintiff as well. So she is present. I just wanted to let you know who was sitting next to me, Your Honor.
That was my guess. I thought it was like a movie star, but I guess I decided it was Emily.
Definitely
Bittner.
not a movie star.
All right, Mr. Pianowski, why don't you have a seat right over here? All right. Thank you for your patience. You sat through some landlord-tenant and some other small claims issues. We had 5 cases set for today. Fortunately, 3 of them washed out, but that left 2 cases. This case is Brian and Emily Bittner versus Stephen Pianowski. You're Brian Bittner?
Yes, Your Honor.
And you're Emily Bittner?
Yes, Your Honor.
And you're Stephen Pianowski?
Yes, Your Honor.
All right, will everyone please raise their right hand? You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, Your Honor.
Yes,
All
Your Honor.
right. Mr. and Mrs. Bittner, you're from Edwardsburg, and Mr. Pianowski's from Centerville, Three Rivers. One time he lived around the corner from me, was a neighbor of mine at Fisher Lake. So I've known him and known who he was, knew his son, knew his daughter. But I don't feel that I would be unable to hear this case. Mr. Pianowski, do you have any objection to me hearing this matter?
No, sir, I do not.
Mr. and Mrs. Bittner, do you?
No, sir.
I never was in his home. He was never in my home, but he's a local guy. I know him. I used to speak to him and his girlfriend when I'd ride my bike past their house or that sort of thing, but I don't think it's a kind of a relationship that would prohibit me from hearing this case. All right, this has to do with a house that was for sale here in Centerville, which is known as the Al Merck House to people that live in Centerville. And Mr. Pianowski bought it, and the Bittners were interested in buying it. They put down a $5,000 security deposit or earnest money in escrow with their insurance agent. Mr. Pianowski, so they filed a claim for $7,000. Mr. Pianowski has filed a counterclaim where he claims $7,000 in counterclaim damages. In the meantime, this $5,000 has been sitting in escrow for more than a year. Mr. Bittner would like to have that earnest money returned to him. This has to do with the purchase of this house, and in part there was an issue about whether plaintiffs could keep or maintain horses on this property, among other issues regarding the actual size of the parcel and some other issues. It was hard to track it all through the telephone text. But Mr. and Mrs. Bittner, this is a very fine home, maybe the finest home in Centerville. You were interested in purchasing it with the intention to keep and maintain horses there?
Eventually, yes, Your Honor.
All right, tell me about, oh, first of all, I need to have everybody raise their right hand. Did I do this already?
Yes, sir, you did.
All right, I did. Everybody's been sworn. All right, then go ahead. You intended to buy this house and maintain horses and perhaps other things. So what was your intention in buying this home and moving to Centerville?
Yes, Your Honor. I have prepared a statement. Is it okay if I read from that to present our case?
Yes.
Thank you, sir. All right. Good afternoon, Your Honor. On behalf of my wife, Emily, and I, we would like to take a moment and thank you and the court for taking time today to consider our case. Emily and I never wanted it to come to this. All we ever asked at various times over the past 19 months is that our earnest money be returned to us in adherence to paragraph 27 on page 6 of the authorized buy and sell agreement, where it specifically states that the offer made is not accepted or if the sale is not closed due to a failure to satisfy a contingency specified herein for a reason other than default of buyer, the earnest money shall be returned to the buyer. The defendant has continually denied signing the mutual release of buy and sell agreement, and therefore we feel as though we have no other recourse other than what has brought us here today. In early May of 2024, our family was living in the Dayton, Ohio area as I had just retired from the Air Force. Given that my wife and I are both from Elkhart County, we began looking to buy a house in the area so we could move back closer to friends and family. At the start of our process, we did not have an agent representing us, and I reached out to Berkshire Hathaway, the brokers representing the defendant, to see about showing a residence he had listed for sale at 598 Anthony Drive in Centerville. Mr. Joshua Nagy, the defendant's listing agent, was not available to show us the house, and Miss Mary Rosenberry agreed to show us the property. While we were touring the house, Miss Rosenberry informed us there was another 2 parcels available to purchase to go along with the parcel the residence was on, which was 6.26 acres. We had inquired as to how many additional acres there was, and she told us about the GIS database that shows all the parcels. When we pulled it up, she showed us how it works. It was identified that there was 2 additional parcels belonging to the defendant, one listed at 5.91 acres and the other at 1.32 acres, bringing the total available acreage for purchase to 13.49 acres. After the viewing of the defendant's...
All right, now let me stop you.
Yes, sir.
Some of this acreage is the house. There's
Correct.
a very large house and an outbuilding and a very large lawn. How
Yes,
much
sir.
acreage was the actual house?
That was on the 6.26 acreage lot, Your Honor.
All right. And there was an adjacent 5.91 acres potentially for sale and an additional 1.32 acres.
Correct. And that was directly across the street on Anthony Drive.
All right. Mr. Pianowski, do you agree with everything they're saying so far?
Yes.
All right, we're all on the same page, so go ahead.
Yes, sir. Thank you, Your Honor. After the viewing of the defendant's residence, Emily and I returned to Ohio with our 3 children and discussed what we wanted to do. At that time, we also decided to hire an agent that we had contacted previously after viewing houses in Middlebury. From that point, all contact we had was through our agent. Before submitting an offer, we were told that the property fell.
All right, Josh Nagy and Mary Rosenberry were the seller's agent. Who was your agent?
His name was Rich Carpenter with Bright Star Realtors.
All right, he's all over in the texts and emails.
Yes, sir.
All right, go ahead.
Okay. It fell within the village limits. Therefore, we believe there was a special conveyance that allowed the property horses, which was one thing my wife had wanted in a property. They weren't certain, but we would follow up and see if there was any formal notification of that. We also inquired about chickens and were told there were others in the area that had chickens without any issues. After Emily and I discussed...
Well, let me back up for a minute because horses is a large component of this. So you're looking for the house, and in this original showing or listing for Mr. Nagy, and I've looked at the pleadings, was there mention that it would be available for maintaining horses?
We were told that they believed there was a special conveyance for the horses, although it did reside within the village limits. Your Honor,
Who
this was
told you
not,
that?
this was not given to us originally when we viewed the house. It was later on after we had inquired. We had raised some questions to our realtor. We did make it known, I believe to Ms. Rosenberry, that we were interested in eventually having horses, but that it might be complicated because, as you know, it was the last property within the village limits of Centerville. And so then upon hiring our agent, then he ran it down a little bit more for us. And that's when they found out that there had been previously a special conveyance from the previous owner. I believe you said his name was Merck.
Yes. Mr. Pianowski, did you buy this from Al Merck or was there a buyer in between there?
I bought it from Elmer.
All right, at one point, a doctor was gonna buy it. I don't remember what happened. That deal didn't go through. And so, all right, so you bought it from the original person that built it?
Yes, sir.
All right. All right, go ahead, Mr. Bittner.
Yes, sir. So after Emily and I had discussed, we decided to submit an offer through our agent for $670,000 that we between she and I broke down to giving him the full asking price of $599.9 for the house, and then $70,100 for the additional 7.3 acres of vacant property, roughly $10,000 an acre. The offer was written by our realtor, and Emily and I both signed the document on 16 May 2024, giving the defendant until 5 p.m. on 17 May to accept. He accepted the offer on 19 May 2024 at 9:15, as seen via
All right,
his
slow
digital
down.
signature. Yes, sir.
All right, so they accept your offer for the house and the land, $670,000. All right, then the clock starts to tick. So you make an offer, they accept your offer, 8/19. What point do you put up the earnest money?
So on 21 May 2024, we made a $5,000 earnest payment that was deposited by the broker on 24 May.
All right. All right, continue.
On 22 May, I spoke with Doug Kuhlman, who works in the zoning department. We had a lengthy conversation about the special conveyance that was given to the previous owners, but that the approving board did not have the authority to do so, and that the special conveyance was being revoked. He and I continued to talk about other alternatives, including us trying to buy connecting pieces of property by other individuals that we could then use for housing a barn and horses.
What was the problem?
What was the problem?
Yes, the house was in the city limits and the other land was outside the city limits, but it wasn't enough to keep horses?
No, sir. All the other parcels that Mr. Pianowski had offered for sale were actually north of the parcel that the house was on. Therefore, those were still within the village limits of Centerville.
All right.
And he said that the board, upon further review, did not have the authority to approve that special conveyance, and therefore he had sent a revocation letter concerning that. But however, it was sent to Mr. Merck and not Mr. Pianowski.
All right. So you make an offer to purchase this house for a price. People
Yes,
could
sir.
see this house, they would say, that's a lot of money, but that's a lot of house.
It is, yes, sir.
So, all right, you make an offer, I'll buy it. Mr. Pianowski accepts it in good faith. Then after you make the offer, you realize, hey, I can't keep horses on here. How is that a problem to Mr. Pianowski?
That is not an offer, or that is not a problem per se. These fall under our inspection provisions that were allowed during the contract period to have further inspections done and find out zoning issues, which is even stated in the purchase agreement that we are allowed to have inspections for zoning purposes also, which I believe this would fall under. And then additionally, Your Honor, shortly after the revelation about the horses, it was noted that when we were looking at the GIS, the lot lines for the additional parcels that we were purchasing, the one identified as 5.91 acres, which is parcel number 04277707500, while it was listed as nearly the same amount of acreage as what the house was on, it was not close to being the same size lot lines. Therefore, I raised the questions, and we raised the question to our realtor, which in turn reached out to Mr. Nagy, and they confirmed that what we were getting was 13.49 acres. But what we were also told at that time was that in the summer of 2023, Mr. Pianowski had sold off 3 1-acre lots to other members of the community. And while those were reflected on the GIS as being now owned by other members, the acreage that was for that parcel number was not changed from the original 5.91. And so it was not actually 5.91 acres that that lot therefore was. It was down to 2.68 acres. And if you were to view the GIS now, even though it says 5.91 acres in the tax description on GIS, it shows that it says now 2.68 plus or minus acres.
All right, so you
Actually
made a
lost
bid
3
on
acres.
what you thought was 5.91 acres, but he had sold off 3 1-acre parcels. So it was less than half of the lot size you thought it was.
Yes, Your Honor. And so then after we found that out, we had submitted an amendment to the contract agreement, asking Mr. Pianowski, because as I mentioned, we had based our offer off of roughly $10,000 per acre, that since the 3 acres was sold off and not known to us until after we were on contract, that he lower the asking price, or that we offer $30,000 less and ask him to accept $640 in light of the 3 acres not being there.
What was his response?
It was quickly denied, Your Honor. And on page 18 of the text messages that I have between myself and my realtor, and I'm pulling it up right now, it was said that spoke with other agent, and as I assume the seller is not interested in negotiating price at all. According to him, seller said $670,000 or deal is off.
All right. So at some point, the deal was off. At what point did you pull the pin and say, we don't wish to go forward?
Yes, Your Honor. So again, this was on 29 May that we had submitted this. Mr. Nagy had asked for it in writing, so we officially gave them that request on 30 May. Mr. Pianowski rejected it on 30 May. And by 1 June, we had signed the mutual agreement to release us from the contract. And then
you signed it. You signed it?
Correct, Your Honor. Signed it on 1 May and on 1 June. I apologize, 1 June of 2024. And on 2 June 2024, the house was listed and back on the market as available. And from that time,
now you're out your $5,000 earnest money. You sued for $7,000. What's the additional $2,000?
Yes, sir. So in addition to the $5,000, the $2,000 we are claiming for general non-economic damages stemming from emotional distress and mental anguish. Between the periods of July 2024 and March 2025, Emily and I reached out to Mr. Nagy no less than 12 times via phone calls and 8 text messages, on top of the times our agent reached out to him trying to rectify this situation. When we purchased our current home in Edwardsburg in July of this year, 2025, we had to make up the additional $5,000 through other measures of savings to cover the lost funds that.
Where did you actually end up purchasing a home?
I'm sorry, what was your question, Your Honor?
Where did you actually end up purchasing a home?
Edwardsburg.
Well, Edwardsburg's a nice town, but this was a very nice house for that price, and Centerville's a nice town with an excellent school district.
Yes, Your Honor.
Well, let's hear from Mr. Pianowski. They thought they could put horses there. They learned they couldn't. They thought they were buying a certain size parcel of property, and they learned it was 3 acres less. You've countersued for $7,000. Plaintiff did not honor purchase agreement, and it cost me 65 days of my house being off market. I lost my backup buyer. Your contention is it wasn't your problem to know whether horses were allowed to be on there or not. There's some commentary from the agents about whether horses were allowed or weren't allowed, and there was a talk about this variance or exception. To my knowledge, there never were horses on there, but that was after they made the offer. But his contention that the parcel wasn't as big as represented certainly does seem to have merit. What's your response?
Regarding the acreage, the acres were never listed in the original listing. The legal descriptions were, and my understanding is that it would be up to the buyer to ascertain what the acreages of those parcels were, the sum total of all of them. And but no representation was ever made by me or the written listing itself stating that there's any acreage amount whatsoever. I'm guessing here what part of the issue is that after I sold those other lots, that the acreages were never updated at the county level or the township. I'm not sure which you call that, but they may have been somehow misled by what the county has listed on their GIS. But at no time did I ever say how many acres there were. I was selling, the lots as described, as surveyed, and the price was the $670,000 total for the 3 lots. So I don't really feel that I misrepresented anything. Everything is common knowledge. And with regard to the horses, if I may, horses were never advertised as being allowed on the original listing. I do believe at one point in the grand scheme of things here that my realtor asked me about horses. And I says, as a matter of fact, when I purchased the property, Al Merck furnished me with the variance, which I relied on when I negotiated the price with him. However, I never intended to have horses. I never did have horses. So it really was a moot point to me, and I didn't really care. But I did retain that document, and I believe you have that document in front of you. Whether or not Doug Coolman rejected it or not, he never rejected it to me other than on the phone. And I asked him for his proof that he rejected it, and he failed to provide it to me. So I think that was on him.
There's an email on page 1 of, I think it's the plaintiff's claim. Just got off the phone with the seller. He is going to review all the purchase documents tonight and get them signed very soon. As far as horses, there is a variance for that property to allow horses. Seller's in the process of locating that document. It might come up in the title search, but I haven't seen it yet. And I know for a fact there's another that had chickens. Now, this is his agent, not yours. But there was a discussion between his agent and your agent that there was a variance to allow horses. All right, this matter is really relatively straightforward. It's not worth $7,000 to the Bittners. You can't sue for emotional distress and non-economic damages in small claims court. You can sue in general civil court, but you can't in small claims. Small claims are only about money damages. You sold the house, I believe, 26 days later, somewhere I read. Your pleading said 46, but I thought it was 26 days later it sold. And so earnest money, as you say, is to show that you have skin in the game, that you're willing to actually go for. This is a big purchase. This is a lot of money. Most people will never buy a house that is this expensive, but $5,000 is earnest money to show that they are willing to go through with it. There was a representation at some point that there was a variance for horses. But the other issue, whether it's your fault or their fault, it's maybe the city's fault, that if somebody were to look this up from the GIS, Governmental Information Systems, or I can't remember what it stands for, but which people regularly use to look at real estate parcels, it shows it was bigger than it was. They were buying 3 acres less. And I don't think that they would have known by doing the property descriptions on the property. They weren't ready to do actual deeds yet. So I think that's a legitimate reason for them to cancel this contract. They were buying 3 acres less than they thought. You were willing to compromise on those $10,000 an acre, so the deal collapsed. So Mr. Pianowski, I ordered that you pay $5,000 plus court costs, or sign the release for the earnest money. As you said, you never actually got the money. I can't order you to sign the release. I could in general civil court, but not small claims. I order you to pay $5,000. And I'm sure you'd rather sign the release and give them their $5,000 back. Then pay $5,000 out of your pocket. I find $5,000 for the plaintiff. And $86.25. Defendant may sign release of earnest money I didn't spell earnest right. And then you would owe a total of $86.25.
And Your Honor, is that to cover our court costs for the filing?
Yes.
Copy. Thank you, sir.
The counterclaim is denied. It's time to release the $5,000 earnest money. The defendants acted in good faith. The horse issue was somewhat vague, but it would have led a buyer to believe that there was a variance that allowed horses, and they discovered that there wasn't. And that's part of the further zoning inspection. Hey, we thought we could get horses. We looked further into it and we can't. That's reason one. Reason two, they thought they were buying 3 more acres of land than they actually were by relying on the county GIS system. That's not your fault or their fault, but it's somebody's fault. And they're entitled to pull out of the contract. If you would have backed up $30,000, the deal would have gone through. I don't know what it actually ultimately sold for. So yes. Now, theoretically, this is due within 30 days. So in essence, you've got 30 days to sign the release of the earnest money with your real estate agents. The money can be released to them. There's a new owner of the house. This is a bad chapter for everybody concerned, and they do get $86.25 for filing this claim to compel the return of the $5,000. All right, Mr. Pianowski, if you go out to the counter, you can get a copy of this, but that's my finding. They're entitled to their earnest money return, nothing more than that. There's no counterclaim. There's no showing that you lost X amount of money by selling this house 26 days later. I don't know what the actual sale price was. I guess I don't need to know. They get their earnest money back. All right. Now, if they don't, I'm sure he'll do it. He doesn't need to pay $5,000 out of his pocket. Well, all he needs to do is sign the release. He does still owe $86.25, but that has to happen within 30 days, or you can ask for a discovery subpoena to compel it. All right, Mr. Pianowski, if you go out to the counter, you can get a copy of that. We'll mail you a copy. I assume he'll sign it within 30 days and you'll get your earnest money back.
Thank you, Your Honor. And again,
May
I address?
There's really nothing more to say. We'll just leave it for that. Hopefully you'll get your money and everybody can have a better 2026.
Yep. Hopefully you'll get your money and everybody will have a better 2026. This is just the beginning of New Year's week, ladies and gentlemen. We'll be live every night this week, even New Year's night. Even New Year's night. I have some things I need to get out of the archives and get played, so we're gonna do it. I have two big long cases. One is a Judge Simpson. Yeah, one is a Judge Simpson, and the other is a mystery judge. I will leave for New Year's night, but man, is it interesting. Ladies and gentlemen, I'm your humble lone wolf Usul. I'm your curator for these here videos. I'm your host for this here channel at the Court Gallery, and thank you very much for hanging out with me and chatting and chat tonight. It's been a pleasure presenting these court cases from today, and we'll see you again tomorrow. Thank you very much. I am your lone wolf Usul, and I am out of here. Have a great night. It's the funky cold Medina.